Hello friends, in the series on the income tax cases, today we will discuss a very limited issue on the concept of depreciation. The limited issue was that whether the assessee is entitled to claim the depreciation on the cost of expressway which has been made by the assessee in an agreement with the state government and consequently in an agreement with the Highway Authority of India, and this agreement was on the basis of concessionary agreement and ultimately the asset is to be transferred to the state government. So whether in these facts the assessee can claim the depreciation on these expressway cost, this issue has been very well taken up by the Mumbai ITAT E-Bench in the case of Hazaribagh Ranchi Expressway Limited versus Assistant Commissioner of Income Tax, and this case is reported in 115 ITR Tribunal Short Notes 46 and the date of the judgment is 17th September 2024. In the present case, the assessee had an build operate agreement basis with the Highway Authority in collaboration with the state government, and according to that agreement the assessee has developed a expressway under a concessionary agreement with Highway Authority, giving right to the assessee to receive annuity on toll road for a period of 18 years. The broad concept was that the assessee will build the expressway, the assessee will collect the toll charges, and after 18 years the assessee will hand over the road to the state government. When the assessee built the road, the assessee claimed depreciation at the rate of 15% on the cost of this road on the pretext that any asset which is used for the purposes of the business, that is a plant, and accordingly the depreciation at the rate of 15% should be allowed to the assessee. When the assessment proceedings were going on and the assessee was asked to explain that why the depreciation should not be denied to the assessee because the assessee is not the owner of the road, the assessee pleaded that the depreciation at the rate of 15% should be allowed to the assessee if the road is treated as a plant. The depreciation at the rate of 10% should be provided to the assessee if the road is treated as building, and if the revenue treats the road as an intangible asset, then the depreciation at the rate of 25% should be allowed. After hearing the submissions and going through the submissions of the assessee, the learned assessing officer was of the correct considered view that in the present case, since the assessee is not the owner of the asset as apparent from the concessionary agreement, since the whole agreement was a lease agreement and at the end of the 18 years the road is to be transferred to the state government, so it is very lucid from the facts of the case that the assessee is not the owner of the road. So in any case the depreciation should not be provided and allowed to the assessee. But alternatively, the learned assessing officer, by taking the shelter of circular number 9 of 2014 dated 23rd April 2014, allowed the assessee the 1/18th cost of the road as a deferred revenue expenditure, and the learned assessing officer was of the view that in the present facts and circumstances, according to the explanation 3A of section 32 subsection 1 clause II, the assessing cannot take the benefit of saying that the asset is a tangible asset because the toll roads and toll bridges are not the tangible assets, according to explanation 3A to section 32 subsection 1 clause II. And alternatively, the learned assessing officer was of the view that in the present case the toll roads and toll bridges also cannot be considered as intangible assets as per explanation 3B to section 32. So in any case the depreciation should not be allowed to the assessee. This view was upheld by the CIT appeal and after that the tribunal. So the assessee was allowed the amortization as 1/18th cost of the road and denied depreciation under section 32. At the end of this video, once again I am repeating the name of the case. The name of the case is Hazaribagh Ranchi Expressway Limited versus Assistant Commissioner of Income Tax, and this case is reported in 115 ITR Tribunal Short Note 46, and the date of the judgment is 17th September 2024. Thank you, friends.